You're going correct.
All right, cool. Now I'm here, and we have another account. So that's cool. You get two of me. All right. I am trying to figure out, are they not back yet? Hang on a second. I got huffing dogs. What is this? Blah, 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 blah. Broken Baker, what's happening, man? Yeah, it's awesome, isn't it, Baker? I'm trying to break the internet. See, I'm on here, but I'm not on here. And there's a trial, but it's not a trial. They should be back from lunch. I don't know what's going on. So I'm going to cut across over here. Dun, dun, dun. There's a car exactly the same as the one I'm in. Why are there all these schools out here? That's cool. All right. Hey, a tuxedo place. Never know when I need a penguin suit. All right, let's see here. Um, Taco Bell would be an improvement, wouldn't it? Yeah, that guy's walking around back there, so it's still alive. Okay. Just waiting on the afternoon trial. Boy, that's funny. Hey, fast group. It is look at that. That's cool. Oh, hey, check this out. Ooh, what if I did this? Boom. And then aha, now I am in control. Oh yes. Yes. Oh, little D. Oh, Danielle. Yes. So, yeah, the did the ride to Dollywood yesterday from Bucky's, and it was a it was the smexy stuff, as you call it. So it was a unique experience, to say the least. No, you can't get in that bag. So what happens if I do this? Ooh, that's fancy. Hey, get out of that. Hey, hey, you can't have this down here. No, no, ma'am, that's not yours. No. Get some coonhound problems. Hey, blue dog, be good, behave. Already bad enough I have to get you out. Oh, wait a second. What happens if I do? There you go. Coonhound. She's the real expert. I just got a notification. I don't know what it is, but all right. You guys have blue dog now. Somebody let me know if court comes back and they don't talk. It should work. Everything should be working. I'm a trained broadcast professional. No, I'm not. All right. So some people they do this crazy thing where they walk with their dogs. Yeah, it's crazy, isn't it? Like that's so much exercise. And I take my dogs for rides. Sells them down. No, hey, the exciting part is that the white rabbit is gone. I am on my own. That was a unwise decision on her part. She'd never leave me alone. Oops. Hey, that's a cool looking place right there. I just found a dollhouse. That's cool. I have no idea where I am. I went the wrong way from where I wanted to go, so now I'm just running the dogs around. I need to find a Chick-fil-A for them. Whoops. I know I can't look at the chat. I'm sorry. Yesterday I did, so I did the Dollywood stream, right? I want to do a video series on a old case. Oh, wait a second. I know where I want to go. Oh, I do know where I want to go. Let's see if I can find this. Let's see what this says. Mountain Hill Park. Come on. All right, so there was a case. It was a long time ago. I have no idea. I heard about it. I heard that I should check it out, and you guys would appreciate it. I do not know how to properly pronounce the last name of the family. It's Lillywid, I think, and they were in East Tennessee, and we're coming back from look, a new subdivision, from a uh, church revival. On the way home, they stopped at a rest area. Oh, something's happening. Oh, Broken Baker just liked something on Twitter. He's the Broken Baker is like the only person I have notifications turned on for. I just realized that because usually by the time he gets to it, it's so different than my time that it's weird. I like it. It's just the way my brain works. Anyway, they can make it in court yet, so I can stop talking. So anyway, this Lily Lake case, right, is like teenagers. They were like from Kentucky or something, and rumor was they were Satanists, and they found this family um, at a rest area, and they kidnapped the family, and then the family's out like eating at like a picnic table or something like that. It's weird. This whole story's weird. And anyway, they kidnapped the family, and I'm gonna go up here and see what's up here. Oh, wait, I am really in a wrong part of town. Anyway, so they wanted their van, their minivan, and they ended up killing the family. There goes monetization. So if you're here, you're here. Oh, by the way, if Baker's still here, man, how's that case going? You're into like closing or like jury instructions, is that right? You need to get Lost Souls over hang out with you. She was doing it too. She's got a good channel. I think you'd like her. Anyway, uh, so they killed his family for their minivan, and then wow, holy cow! It's like I find something, I'm like, wish the White Rabbit was here. Also, so she can tell me how to get back. But their goal was to go to Mexico. It's always Mexico, right? Uh-oh. We lost Blue Dog. Blue Dog says, I'm bored with this. What are we doing? I don't know. I don't even know if I have service out here, to tell you the truth. So I may be talking to myself. I can't see the phone. Don't know if I have service. There's no lines on the road. This seems like a Friday night for me. Tell you the truth, you guys know why Friday Night Live is a thing? Keeps me out of trouble. Keeps me out of trouble. I know right now that I am not where I belong. Holy cow! This is like early. This is early frontier area where I am. When I say early frontier, I'm talking like 1750s. Holy smokes! Oh, there's a lake. I should be showing you guys this drive instead of whatever it is I'm doing. Guys, I know I promised you a Chick-fil-A, but to tell you the truth, I'd just be glad if I could get a, hope I have a signal. Oh, well, that's nice, isn't it? I mean, I'm driving in the middle of the road because there's no edge of the road left. I mean, I've got to find civilization. I have no idea where I am. I have zero idea, but they're building new houses. Oh, that's gonna be a big place. Holy moly. This is really out of my price range. You ever drive by huge houses and wonder what do these people do? And how do I do it? Which court we come back? Oh, that's not a public road. Still says the park's this way. I'm not seeing it. Trying to take the dogs to a nice day. 66 degrees. Oh, there's another sign that says park. Okay. If this road was a little bit uh, tinier, I would definitely think I'm in some bad situation. No hunting. Oh, cool. But not cool as no hunting. It was a sign to show that there was civilization still left. All right, that is closed off right there. Oh, it's a dog walk. Oh, well, this is cool. I need a boat. Are we back in court yet? No. We still have Blue Dog. She's looking. All right. Dude, that guy's got a cool dog. All right, let's see here. Oh, look, there's like a playground and everything up there. This is so crazy. I have no idea what I found. I realize I need some more camera equipment. Not only do I need that 360-degree camera, I need a gimbal. All right, hang on a second. All right, there we go. All right, let me see what's going on. Hey, I have a story. How you doing? News story was annoying to get through. Thanks, though. Tia, the puppers are so well behaved too. Tia, they love riding. Yeah, it takes Blue Dog definitely wants a pup cup. Yeah, I have a story. If you hear banjos turn around, dude, I don't even know if I can make it there. Yeah, they're still moving around in the courtroom. Okay, that's good. So it's still a live feed. Iris, how are you doing? Yeah, she is pretty boss. Let's see here. Let me do. Okay, let's see if I can do this. This is gonna be. I'm gonna get in trouble. Watch this. Everything's gonna mess up before it's over with. Wait, why didn't that work? Okay, there we go. That goes like that, then like that, and then so do this. I'll do that. Whoops, wrong way. All right, now let me go to more. Go to settings, camera. Um, oh, that's cool. Now let's see if I do. Oh, all right, cool. Now, can I do the layout a little differently? Do it like this. Oh, there we are. Okay, so now you guys see when they come back to court, I'll switch to everything around. You guys see, told you, I was like, oh man, there's a lake. How crazy is that? Like, this is a pretty lake. I had no idea it was here. I don't think that lady did either. She's doing yoga. Yeah, the dogs are not going to get yoga. All right. So, yeah, that was pretty cool. I'll take you guys for a ride again. Stacey Ann, how are you doing? Let's see. Boom, boom. All right. Now we're back on our quest for the pop cups from Chick-fil-A. I know. I see you, baby girl. She is. I kid you not. She's upset that she's not on screen anymore. She just started to paw at the display. I wonder if I can turn this. I see her. Probably shouldn't do this while I'm driving. Okay. All right. Oh wow. What's this? And I have no idea what this is. That is a weird looking. Oh, it's the water treatment facility. Wonderful. What a beautiful lake. Oh, look, it's the water treatment facility. Nothing like the going down the county reservoir. All right, get these puppers out of here. Boy, I wish you guys could see. Brown Dog has got his head outside the window. Maybe I should go. Whoops. Danielle on Twitter. I don't know if she tweeted that or if that's a private message. I better not read it. I wish I could control the sound of notifications. Where is the judge? Earlier today, they left the sound on in there. It was hilarious hearing everybody talk because it's courtroom banter. Uh, let me tell you what, working in a courthouse, my experience of seeing it, uh, it is the exact same way as like YouTube. You're sitting there all day. You got like crazy stuff happens. People come in, off the street. It's funny. One time I was in the courthouse and they have, I can't remember if they put metal detectors in yet or not. But anyway, this guy, he looks to be like in his 60s, maybe 70s. I don't know. He's a country dude, so he might have been in his 50s. Just looks like he's in his 70s, right? And blue jeans, short sleeve. Just, I mean, it looks like a farmer. He had he had like an old, like a Bowie shaped knife, but it wasn't real long. It's like maybe a 5 inch hand blade, but overall length of like maybe like 9 inches, something like that. Anyway, it was on scabbard. I mean, it looked like he probably made this thing, or like it was inherited type thing. Anyway, um, he was walking around the courthouse, and a bailiff, this chick bailiff, starts yelling for him. Oh yeah, how do wait? This one was he the one? No, I take it back. Yeah, that's how I remembered him. He did. He had his knife on him, and this chick bailiff starts yelling for him, and I'm looking up, and I'm like, oh gosh, like he's in trouble having that knife in here, right? Because pretty sure I don't know if you can carry a knife or not. Everything got weird in courts in the last few years. So anyway, um, but anyway, so he's walking around, and he starts to walk out this door, and it had "Do not exit" written on the door. So the uh, bailiff chick, she starts screaming at him, "Sir, sir, sir!" And he finally like goes to maybe like touch him on the shoulders like that. He turned around and like, "Oh, I'm sorry." And she says, "Can't you read that sign?" He's going out the emergency exit, right? This guy looks at her, just serious as day is long, and says, "No, ma'am, I can't read that sign." Dude, that broke my heart. Um, Absolutely broke my heart. And I think the bailiff wasn't prepared for it. She's like, "Well, it says do not exit. You can't go out that way. You got to go this way." And bailiffs they're a different breed. But anyway, so uh, he goes out there trying or whatever. But anyway, it got me, man. It really got me because I was like, that's the type of person that like you have someone like me who actually cares about the dude, Actually, I don't know. This is the sappy part. God, I hate being sappy. I'm sorry I even brought this up now. But it's like they're the people that I feel bad for, and government is not set up properly for them. You talk about red tape and everything. Like that's the part of it. And like I said, I did not practice like courtroom law. I was a government lawyer guy, and uh, it was a um, my personal description of what was like what was most important to me was to always try to cut the tape out. There's so much stupid stuff, and sometimes you get people in there that they just want to make it hard for other people to do things. And I was like, guys, that's not how it is. Not how it's supposed to be. Oh, okay, we're back, and I'm at a stop sign. Yay! Good days. Good day. You don't have to listen to me anymore.
Mr. Simpson.
Oh, that's loud.
Versus Carl Morganton. That would be
Oh, let's see
CC
here.
20CR150. Mr. Morganton is here. Come up. So this was set for status today, as well as a motion to suppress that I had filed. And speaking of the state,
I cannot find my way out.
it was within 10 days, so the state couldn't get
Oh,
the
wonderful.
DTF agents here today. So basically, we just need to set another
As I
motion
said,
date. I think when the court
we're
was
gonna do this
walking
one.
in, we were wondering if March
There we
4th
go.
might be available. That Monday after the March 1st motion date.
Well, March 4th is our circuit civil docket call at 9 a.m. and 1:30 p.m. is Dickson Chancery, so it's not available. We have criminal trials that are scheduled to start on the 5th.
Oh, it's loud like your face. Oh, what happened?
His plea date is March 12th.
I can't control the volume from here. Sorry, guys. This is streaming on my computer back home.
I don't have an open day between now and the 1st is obviously out. The 4th is circuit civil docket call at 9, 1:30 Chancery. On the 5th of March, we have Dickson criminal trials. And 6th, we start the Haley Brown vehicular homicide, which will last the rest of the week. There are other cases that are set. On the 11th, I have a criminal docket. 12th, criminal docket. 13th, we start the State versus Devin Pollard, a rape case, which is supposed to last at least a couple of days, if not the rest of that week. On the 15th, it's our DUI day, which is all day DUIs. 18th, I have Dickson Chancery. 19th, and 20th, and 21st are the judicial conference. 22nd is the State versus Howard Hogan criminal trials. I'm sure there are other things set that day. The 25th, we have Dickson criminal trials, Robert Capes. The 26th, we have a VOP for bail. 1:30 that afternoon, I have the State versus BJ Brown attempted first degree murder sentencing hearing. 27th is DOP for those in jail.
I wish I was writing all this down.
28th, I have a half day Dickson Chancery. On the 29th is Good Friday, and I am out having so that kind of tells you where we are.
Yes, Judge.
April, I go to Humphreys County, but even though I've given out a bunch of days for trials in Dickson County, April the 2nd, April 1st, I've got Humphreys County Circuit Civil and 9 and then 10:30 Chancery. And 2nd, I've got to come back here with the estate of Robert Harrell, a one-day jury will contest. Then the 3rd is Chancery in Waverly. 4th is Chancery here. 5th is Chancery in Waverly. 8th is criminal docket call in Waverly. And I have criminal trials the rest of that week in Humphreys County. Then I come back here on the 15th of April for criminal trials in Dickson County through the 19th. And I also come back here for criminal trials the 22nd through the 23rd and the 30th, 29th through the 30th. Then on 24th of April, VOP in Waverly, and 25th is Cheatham Chancery, and 26th is Humphreys Chancery. So when I pull out of my driveway, I'm not sure exactly which direction I need to turn. So.
I understand, Your Honor. If we need to, I mean, I'm open to whatever suggestions the state might have.
So you need a time to hear your motion. Is that what you're saying?
Yes, Your Honor. I mean, and basically the situation with this case is that it's an older case that I inherited from Ms. Jones, so I'm kind of new to the file, and this is, I think, the first setting that I've been involved with, which is why the motion to suppress is only coming now.
There is an outside chance that the contested divorce I'm hearing tomorrow in Cheatham County.
Blue Dog
That
unplugged
we
the
set
feed.
aside 2 days, it may only last 1 day. That's when one of the lawyers says, I want it to end in 1 day. The other one didn't say anything, so I can't guarantee it, but we might be able to do it Friday.
I would need to confirm with my witnesses, but I can pencil that in.
Confirm with whoever you need to see if you can set it up for that time, and let's go from there.
This
Judge,
judge.
would that be at 1:30?
1:30 on, how long do you think it'll take?
I think it'll take at least 2-3 hours, if I had to guess, if I was being generous, I don't want to
Going
give
back to
too
the
short of a
housing, I
time. I
have
don't
to
think it's going to be a
rewind
short
and
hearing. I know
watch
the
this
state
for
has
all
at
the
least 2
dates down.
witnesses.
I
may
really
have
like this. Like,
one
if
or more witnesses as well.
Well, let's set it for 1:30 that afternoon. And I'll have to let you know whether or not that divorce case ends, because if it is still going, we'll have to reset it. So.
Judge, would that be in Cheatham as well?
No, we'll come here to do it.
I got itchy face.
Thank you, Your Honor. And then I guess we'll just for now keep the same plea date and the same trial date.
Right.
Thank you. See, I'll let you know if you need to come around Friday. Okay? Hopefully you'll know when I can. Just be by your phone.
Oh, do we have inmates here? Let's bring out the first one.
Oh. Come on in front of me.
His email from court today. So that he didn't get to step around.
Fordyce, I wasn't sure if you had anything else on the docket today. Do you? You're muted. You'll have to unmute your device.
Yes, sir. I have Jasmine Williams. She's in custody and the bonding company has asked to be relieved in that case.
Is that the only reason that it's on the docket today?
That is my understanding, yes, sir.
Good morning. What is your name?
Brittany Ellerby.
All right, Ms. Fordyce, I'll come back to you as soon as we're able to get to your client.
I just did a big circle and don't know how I did it. Anyway, so I just found out earlier watching this with y'all
18 and 19.
that
Judge, I agreed to stand
I
in.
think
Attorney Eric
a
Morrison.
guy I went to
on Ms.
law school
Ellerby's
with ran
case.
against
My
Judge
understanding
Wolfe.
is it's going to be a plea. Yes.
I need to find that one out. Oh, what did you do down here, baby? Trying to make you look pretty.
As soon as I can find who has the judgment sheets. I think they're here. I'll let one of you guys do it.
I need to go there. Crud. All right, guys, when is up?
Judge, I'm going to pass forward plea agreement in this case.
All right. I've been handed on Ms. Owenby's case a document indicating that she's going to be entering a plea in docket number 2023 CR1, a plea of guilty to count 1, possession of methamphetamine for resale over 0.5
A
grams.
lot more fur. K grip.
Received a sentence of 16 years to serve at 35%, $3,000 fine and court costs, forfeit all seized property, testify truthfully against co-defendants. This will be served concurrently with 2023 CR21. It is recommended that the defendant complete TDOC TCOM program while incarcerated. Of course, that's obviously beyond my capability. 2023 CR 21, she would be pleading guilty to the amended charge of conspiracy to sell or deliver methamphetamine, a Class B felony. And that would receive a sentence of 16 years to serve at 35%, a $3,000 fine and cost. She would forfeit all seized property and testify truthfully against all co-defendants concurrent with her prior case. Count 3, money laundering, would be dismissed. And 2023 CR 71, she would be pleading to count 1, possession of methamphetamine with intent to sell, receive a sentence of 16 years to serve with 35% release eligibility, $3,000 fine and court costs, forfeit all seized property, testify truthfully against her co-defendants. That would be concurrent with 2023 CR 1 and 21. Counts 2 and 3 and 4 would be dismissed.
Brown dog thinks he doesn't have an affair.
Let's OMB, raise your right hand. Let's place you on the road.
Yes, ma'am.
State your full name on the record.
Brittany Nicole Owenby.
Ms. Owenby, you are here today charged with a number of different offenses, including a Class A felony of conspiracy to distribute or sell drugs. And it has been indicated that you're going to enter a plea of guilty, as I just noted. But have you seen or been shown a copy of those charges and talked them over with your lawyer? And you and Mr. Larson discussed the range of punishment you have facing you, as well as the possible defenses you might have.
Yes, sir.
Well, it's indicated you want to enter a plea of guilty to these charges. Do you understand you can plead not guilty and have a speedy and public trial by jury?
Yes, sir.
Do you understand if you went to trial, you would have the right to have a lawyer and have one appointed for you if you could not afford your own?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted.
Yes, sir.
You
I
understand
think
that if you
emphasis
went to
on
trial,
reasonable
you and
doubt
your
needs
lawyer
to
could
be
confront and cross-examine every witness the state brought in to
more
testify. And you could
emphasized.
bring in your own witnesses by using a subpoena.
Yes, sir.
You understand at trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. You understand that if you went to trial and you were found guilty, you could appeal that judgment and the sentence imposed to the Court of Criminal Appeals and have an attorney appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
Now, that's going to result in some felony convictions that will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
Now, you are charged currently under the conspiracy statute with a Class A felony, which carries, I think, 18 to 25 years in prison. And as a result of that, I think that would that be 100% to serve if you were convicted under that? May not be, I'm not sure.
Judge, I believe it's still at the normal percentage.
But in any event, your plea agreement reduces that charge down to this Class B felony, but still requires you to serve 16 years. And do you understand that that's all I'm doing is giving you a sentence of 16 years? How much of that you actually have to serve is up to the Department of Corrections.
Yes, sir.
We all know it's unlikely you will serve every day of 16 years, but you have to serve a minimum of the percentage of 35% before you can be eligible for parole. So it's good time, other things that you get credit for, that's all up to the state. They're not part of this plea agreement. You understand that?
Yes, sir.
All right. Do you understand everything I've explained to you?
Yes, sir.
And you understand these convictions are going to be on your record in the future to make more severe the punishment
Oh,
you
go to
receive
elbow
if
camp.
you're ever again convicted of a crime.
Yes, sir.
Do you wish to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes.
You understand that if you plead guilty, the court of the state may ask you questions about the offense, and if you answer those questions under oath, on the record and in the presence of your lawyer, your
We're gonna
answers
have
can later
a
be
full
used
trial
against
right
you
here, aren't we?
in a prosecution for perjury if we were to find that you were lying under oath.
Yes, sir.
Do you understand I have to have facts presented to me that will allow me to find you guilty of these offenses? Then are you guilty of this in docket number 2023 CR1? Are you guilty of the possession of methamphetamine for resale?
Yes, sir.
And in docket number 2023 CR21, are you guilty of the amended conspiracy to sell or deliver methamphetamine, Class B felony?
Yes, sir.
Are you guilty of possession of
Wow.
methamphetamine with intent to sell in docket number 71?
Yes, sir.
Generally, I think you were going to have some questions for us. Is that correct?
Judge, I'm just gonna ask you Ms. Owenby, you were interviewed in regards to your participation and your co-defendant's participation in the drug conspiracy. Is that right?
Yes, sir.
And
Oh, wow.
it's okay. It's okay. And what you told the officers in that interview was true and correct.
Yes, sir. Oh, yes, ma'am.
It's okay. And both you and your co-defendant, Robert Sowell, is that I'm saying that right? Sewell? Both you and
Jacob,
Robert Sewell
Blue
were
Tick
involved
Coonhound.
in the purchase and the sale of the methamphetamine. That's it, Judge.
I'm a Cooney.
Right. Are you satisfied with your attorney
We are a
services?
Cooney
You
family.
have a question, Mr. Atchison? Are you satisfied with Mr. Larson, who is representing you in his services?
Yes, sir.
You think he's done a good job of representing you competently?
Yes, sir.
I need
Mr.
to,
Atchison, I know you're standing into
start
Mr.
doing
Larson.
her
Do you know of any reason
TikTok
she should
more.
not enter this plea?
It was Blue TikTok.
Then Brittany Owenby in docket number 2023 CR1, you were found guilty of possession of methamphetamine for resale over 0.5 grams, sentenced to 16 years. Tennessee Department of Corrections to serve at a 35% release eligibility, $3,000 fine and cost. You were to forfeit all seized property, and you're required to testify truthfully against the co-defendants. It is recommended that you complete the TDOC TCOM program while you are incarcerated, and this will be concurrent with all of your other charges. And CR 21, upon your plea of guilty to the amended charge of conspiracy to sell or deliver methamphetamine, you're sentenced to 16 years in the Tennessee Department of Corrections that are 35% release eligibility, a $3,000 fine and cost, forfeit all seized property, and you're required to testify truthfully against any co-defendant, and this will be concurrently with your other case. Count 1 of CR 71, possession of methamphetamine, you're found guilty of that, sentenced to 16 years to serve at 35% release eligibility, $3,000 fine and cost, forfeit all seized property, testify truthfully against your co-defendants. All of these are concurrently, and all remaining counts of any of the indictments are dismissed as a part of this agreement. She gets pre-sentence jail credits from March 6th of 2023 until today. Thank you.
Thank you, Judge.
Don't do meth, kids. Don't do meth.
Your Honor, can we address Joshua Anderson? Do you know if Cheatham, we can put him on the 11th to plead if we need to. I know it's pretty.
Although there's Cheatham Jail, let's see who they have.
Cheatham
At the
County
jail
is
in
where
Cheatham County,
Ryan
can you,
Upchurch is from.
Bring out Mr. Anderson.
Yes, Your Honor, give me 1 second.
Your Honor, I'm Nick Schulenberg. I'm standing in for Mr. Fuson on this plea.
A missing South Carolina teen, pregnant, was found dead after days before.
What were you about to ask me, General Allen?
I'm not really sure. I think
That
on,
makes two of us.
I know.
in that case.
The plea sheet is a fax copy. We can get the original. That was my only other issues. If y'all wanted to put it on another day for us to have the original, we can do that. I'm
When I
good with
started out practicing
whatever the
law
court
many
is.
years ago, we used charcoal that we would just write out what we could on animal skins to,
Did you
try to
tap
get
it
the
out?
plea entered in.
I thought you had a chalkboard.
I don't think we used in the old days a plea sheet form at all.
Okay.
That is not the relevant part. Having a defendant affirm under oath on the record and by video, obviously in this case, that they understand everything and they understand what's going on is, in my opinion, the
I love this guy.
important part.
Thank you.
We now have Mr. Anderson back with us. Mr. Anderson, can you hear me okay?
Barely.
Let me try again. Can you hear me now?
Yes, sir.
All right. Mr. Anderson, you have Mr. Fuson as your lawyer, but he has an associate standing in for him. And I've been handed a sheet of paper that's called a plea of guilty, a nolo contendere waiver of jury trial, that indicates that you are going to enter a plea of guilty to simple possession and a felony possession of a weapon. In simple possession, you're going to receive a sentence of 11 months and 29 days, suspended of probation after 30 days, and that will be concurrent with your second count, which is felony possession of a weapon. You will receive 3 years suspended to supervised probation, and that will be concurrent with the Cheatham County case that you've got of 2024 CR 95164. Is that what you understand the agreement to be?
Yes, sir.
3 and 4, those 2 counts will be dismissed. All right, then I'm going to ask you to raise your right hand and let me place you under oath. You solemnly swear or affirm the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God.
Yes, sir.
All right, Mr. Anderson, I'm going to demonstrate to you this sheet. That appears to be your signature at the bottom. Is that your signature on that document?
Yes, sir.
This is a fax copy or a copy of it. It's not the original, which will come later. But you acknowledge that you did execute this document, correct?
Yes, sir.
Then I want to make sure you understand your rights. Do you understand that you have a right to plead not guilty? First of all, do you understand what you're charged with? And have you and Mr. Fuson, your lawyer, had a chance to talk about what your charges
That's a good
are,
one. What are you charged with, sir? Do you
possible
know?
sentences could be, and what possible defenses you might have? Do you feel like you fully understand everything?
Yes, sir.
Do you understand you have a right to plead not guilty and have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that if you went to trial, you'd have the right to have a lawyer and to have one appointed for you if you could not afford your own?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything?
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state might call to testify against you, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out for you.
Yes, sir.
You understand that's going to result in 2 convictions, 1 misdemeanor, 1 felony, that are going to be on your record in the future to make more severe the punishment you'll receive if you are ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
You want to plead guilty to these 2 charges and give up your right to a trial.
Yes, sir.
Do you
Wow,
understand?
man.
If you plead guilty, the court of the state may ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer who's here in the courtroom, that those answers could later be used against you in a prosecution for perjury if it turns out you were lying under oath.
Yes, sir.
You understand, is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand that I have to have facts. I have to determine that you're guilty, and I have to have a factual basis to support this. Do you understand that?
Yes, sir.
And are you guilty of the simple possession charge?
Yes, sir.
And are you guilty of being in possession of a weapon when you had a felony conviction?
Yes, sir.
All right. Are you satisfied with your attorney services?
Yes, sir.
I feel like Mr. Fuson's done a good job of representing you.
Yes, sir.
As standing in for Mr. Fuson, you know of any reason he should not enter this place?
No, Your Honor.
Any further from the state?
No, Your Honor.
Then Joshua Seth Anderson in docket number 2023 CR 228. Upon your plea of guilty to count 1 simple possession, I find you guilty. Sentence you to 11 months and 29 days in the county jail that will be suspended to probation after 30 days with credit for trial from time served. That will be 30 days. This will be concurrent with count 2 in Cheatham County case 2024 CR 95164. He's ordered to pay a $250 fine, which is the minimum. Count 2, he's found guilty of being a felon in possession of a weapon, sentenced to 3 years Tennessee correction, suspended to supervised probation. That will be concurrent with count 1 and with that Cheatham County case I mentioned before. counts 3 and 4 dismissed as part of the agreement, he gets 30 days pre-sentence jail credit. When you are released, it's going to be incumbent upon you to contact if this is all you have pending against you, I'm not sure it is, you have a Cheatham County case, but you'll be required to contact the probation office as soon as you're released. Make sure that you contact them and begin your probation. You understand that?
Yes, sir. Will that be in Dickson County or Cheatham?
Have you already disposed of the Cheatham County case?
I haven't had a chance to speak with my probation officer yet. No, sir. But I have time for my probation officer.
But you have already pled guilty in the Cheatham County case?
Yes, sir.
Okay. Well, if you're already in the Cheatham
yes,
County
sir.
case and you have a probation officer over there, is that who you?
Is he on state probation right
Hey, big white horse, how you doing?
Yeah, he'll need to get in touch with me.
I hate listening to
You
proceedings.
just contact the probation officer in
Well, you
Cheatham
can
County
hang out with
as soon as
the
you're released and they'll
blue
work
dog.
that out.
Yes, sir.
Thank you.
Thank you.
Oh. No, and also
Right.
Big White
Going
Horse.
over
It's
here
not a
to,
special
I'm
case.
gonna
This is
ask
just
you to own
Dickson County,
the
Tennessee.
device.
I know this area pretty well. Um,
Right,
and
can you tell me what
this
your
is
name
the only
is, sir?
judge in Tennessee I know
I'm
that's doing
Adam
this
James
type of extreme. The Tennessee Supreme Court does them also,
Motion to withdraw. that
but
I
they're
had struck
not.
earlier today.
All right, the only reason you were on the docket is the public defender had
They're not.
filed a
I'd rather
motion to
do
withdraw
criminal
as
stuff.
your
I think this
attorney,
is
but they've
funny.
stricken that
This is
motion
small
for the
time crime.
present time, and they're wanting to
I'm
try
talking
to
over the other
continue to
show. I'm
help you
sorry.
if they're able to do so. That they have a code of ethics, like all lawyers, that they have to follow. So they'll talk to you about the situation and try to see what they can do to help you first. All right? Thank
All
you.
right.
They'll be over to talk with you. Thank you.
It's gonna be a long ride over.
Not that long. I drive over all the time. So where are you?
Bledsoe County.
That is a long drive. So they may want to call you. I thought you were in Cheatham County. So all right. Well, good luck getting
All
there.
Be there on the 29th, Mr. Frazier.
He says he'll be
right.
there.
I'll be here for sure.
I
Like
assumed as
Bledsoe
much.
County.
So,
That's
all
near
right.
Chattanooga, isn't it?
Who do we have? Anybody? Who? Jasmine Williams. That's Miss Fordyce's case.
Yes, sir.
We have Jasmine Williams we're going to bring out. She has a plea date of April 24th and a trial date of May 16th. May I see her file?
And Mr. Wainick just informs me that she
Hello.
pled this morning in General Sessions Court on an 1129 to serve. So, and this is the bonding company's motion to be relieved in this case.
Yes, Jacob. She howls at everything. I call it yelling. She's a yeller.
Mr. Cummins, this is your motion.
You'll see in the packet, Judge, the co-signer, which is Miss Williams' mother, is requesting to be relieved because she goes into detail as to the reasoning.
You okay, bud? So you understand what's going on? Just driving around. Now, this attorney down here in the bottom right She had something to do earlier. MLS, what's happening? Yes, okay,
Williams,
okay.
your,
Actually, I
mother, as
realized
your
I did.
co-signer, has given a long and lengthy
MLS, what's happening,
explanation
man?
of why she's asking to be relieved from co-signing the bond. And based upon that, and it's my understanding that you were convicted this morning in general sessions and sentenced to 11 months, 29-day sentence. So it's a little bit academic about the bonding situation.
You
Anyway, so I'm
guys
going to grant
know,
the
like,
request to be relieved from the bond.
well, you can't hear me right now very well. I'll tell you later.
Ms. Fordyce is your lawyer. She's here on screen with us, and she will be talking with you further about your case and getting it ready for trial. Thank you.
Thank you, Your Honor. Are they still holding you up in the booking?
Ma'am.
Okay.
All right. Thank you. Step back, Ms. Williams. You have anyone else back there?
That was the last one, Judge.
The last one, all right.
All right, Judge, we were waiting on Mr. Roger Wayne to grant his motion. Yeah, that's fine.
All right. Then that concludes all of our inmates. We'll go back to the regular docket. State versus Cordarius Godwin is set for 3 o'clock this afternoon. A motion to revoke bond, is that correct? Mr. Spratt.
He's on his federal call thing right now.
We'll probably take it up as soon as he's finished. Would be ideal before 3 o'clock, so.
I agree.
2022 CR 475 State versus Zaria Mian Haynes.
Yes, Judge. So this one's gonna be mine. I think it's set for a status. This is an appeal of a VOP hearing out of White Bluff Municipal Court, where the notice of appeal that was filed back on sometime in 2022.
That's a weird looking dude.
I'm still kind of trying to get my bearings on what's going on and what needs to happen with this, but that's.
Let me make sure I'm understanding. You're having difficulty understanding what might happen in White Bluff, Tennessee, in a municipal court?
Well, no, I'm familiar. I'm down there. But I'm trying
Who is
to.
this guy?
So I don't know why this case has been pending for as long as it has. I believe Mr. Dugan had filed the notice of appeal before before I became employed with the public
Mr.
defender's
Dugan's still with
office.
the public defender's office.
He's no longer with the public defender's office, but he was at the time that this notice of appeal was filed back in 2022. And my understanding is it's been essentially sitting in a filing cabinet ever since then with no further action on it. So,
Madam Clerk, may I see the case file on Zaria
What is
Mian
happening?
Haynes?
Judge, let me tell you where the petition comes with this.
I'm covered in dog hair.
And the criminal.
Thanks a lot, guys.
And the criminal division thought it was a bound over, so she put it in bound over status.
I'm not, yeah, and I.
It's not enough, it's not a bound over. I don't think she needed to be here.
No, I haven't had any contact with her. I don't even know if I have a good phone number. But I could say that.
Texas Jen, great point there. Turn them and churn them next. Like that's why I like this, because this is where everybody's gonna see. You don't get the sexy stuff. You don't get the these horrible long lasting trials. It's this is real life. This is every day. These are the people you pass. These are the people you're standing next to in the checkout line.
Good news.
Um,
Open cases and sessions.
you know, you see them when you pick up your kids at
Yes,
school, or if you're just sitting here getting ready to go into a place
Do I
and
need to sign it or just?
you're watching this couple, one of which I hope is
Yeah, I
pregnant,
wrote them in. I just didn't remember.
as they
Thank you.
smoke their cigarettes.
Thank you.
She's not pregnant. She's got some stomach issues.
State have anything they want to say about this case, or you even know what I'm talking about?
I know very roughly what's going on.
You know what?
I know that it's an appeal and that the probation officer has been tracking and is aware and ready to testify.
And it's 11 months and 29 days sentence that has now been 2 years pending on appeal.
Now, she has not been reporting during that time. When it was stayed, when the appeal was stayed, she's not been reported during that time. And Judge, I did let Mr. Sensing know, it appears that Ms. Haynes has 2 open cases in general session. So I think we should at least be able to find her.
All right, we're going to set it on the 27th of March, VOP day, and we'll either try it or dismiss it on that day.
Thank you, Judge. Oh, may I ask, Madam Clerk, has the file, the White Bluff file been transmitted to y'all's office, or do I need to get with DC on it? Okay, but, okay. Thank you.
2023 CR 97 State of Tennessee versus Carol Lee Hughes.
Judge, that's also my case. Essentially an aggravated assault case. It's set, I think this is the second setting. We have an agreement we're deep into settlement negotiations, but I understand that there's some medical records that remain outstanding that would be germane to those negotiations. And so I'm just asking to reset it until maybe we can set for status later in March just to keep tracking, or to the court's.
Trial date is March the 6th, according to this docket.
It is, Your Honor, and I had asked the family for medical records, and we were also going to judicially subpoena them. I simply did not stay on top of it and did not realize that the family had not brought them into us. So that's on me. I thought that they were bringing them in. I thought that they'd been brought in. I talked to them yesterday. They said, well, we did bring them in, but then we took them back home, and now we can't find them. So I don't have an excuse other than that, Your Honor.
All right, let's reset it for a date certain. Do you have another trial date?
Where are we going to? September?
An aggravated assault with injury, domestic assault with injury, and aggravated elderly abuse.
Thank you. September 17th?
September the 17th, the last day of the plea, then would be what day?
Danny, do you know what it is?
Ninth.
Ninth.
I'm gonna set it on August the 19th. For status. You can resolve it on that day, we'll let you resolve it.
Thank you, Judge.
All right. Once it goes past the 9th, it will be for trial or plea to the indictment.
Thank you, Your Honor.
All right. Probably. 2023 CR 21 State versus John Robert Hunt. Mr. Wainick.
Judge, that's one of the conspiracy cases that I believe we moved to.
You want to leave it on March 1st then?
Yes, Judge. Well, actually, he's not joined on the motion.
Okay.
Is that a status date for all those?
All of those are being just put for status because we'll actually, no, there's no reason for it. If it's not joined in the motion, there's no reason for him to be here on March 1st. we'll move him to, is he in custody or on bond?
He's on bond and he
We'll
stays
move
in
it to
frequent
August
contact.
19th. That'll be his final plea day. I'll assign a trial date after that.
And I'll let the court know he was here yesterday.
Go, State versus Jeremy Jason Jaco.
Normally people tell me to go away. That's, oh, I'm sorry.
I've been handed a document indicating Mr. Jaco is going to enter a plea of nolo contendere to count 1 an amended charge of simple possession, Class A misdemeanor.
I don't know,
11
fast
months
group.
and 29 days in the county jail, suspended to supervised probation, a $1,000 fine and court costs. Count 2, possession of drug paraphernalia, 1129, suspended to supervised probation, consecutive to count 1, $150 fine and costs. As a condition of his probation, he must complete an alcohol and drug assessment and follow the treatment recommendations. All right, Mr. Jaco, raise your right hand. Let's place you under oath. State your full name for the record.
Jeremy Jason Jaco.
Mr. Jaco, you are here today charged with a 2-count indictment. It's been indicated that you want to enter a plea of no contest, but have you seen or been shown a copy of those charges, talked them over with Mr. Wainick, and discussed with him the range of punishments you're facing as well as any possible defenses you might have? Well, it's indicated you want to enter a plea of no contest or nolo contendere. That simply means you understand what the state's evidence is. You don't plan to contest it, but you're not going to agree to anything. You're not going to admit you did anything. The state will then give me some facts to support a finding of guilt. You understand that? You also understand that you have a right to plead not guilty and have a trial in this court, a speedy and public jury trial. You understand? You got to answer verbally, please.
Yes.
You understand that
Yeah,
you have
answer
the right to have a
verbally.
lawyer and to have one appointed for you if necessary.
Yes.
You understand that if you went to trial, you'd be presumed to be innocent until such time in favor of the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and that verdict will have to be unanimous before you can be convicted of any crime.
Yes.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness against you, and you could bring in your own witnesses by the use of a subpoena.
Yes.
You understand that if you went to trial, you would be presumed to be innocent. You would not
Now
have
he's
to
going to go
testify
right
to prove
into
anything, and no inference of guilt
admitting
would
everything.
arise,
Like,
but
I did it.
testify to
Put me in jail.
Yes.
You understand if you went to trial and you were found guilty, you could appeal that judgment and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you
Is
with that
Leon
appeal.
still here?
You understand that if you went to trial, and
He's
I'm sorry, if
he's
you
my
entered this plea
Domino's
guilty of
buddy.
waiving your right to a trial and to an appeal, all I'm going to do is approve what your lawyers worked out.
Yes.
You understand that that's going to result in 2 misdemeanor convictions and they'll be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes.
You understand that?
Yes.
Say it out loud.
Yes.
All right. You understand everything I've explained to you?
Yes.
Do you want to plead guilty, no contest according to this agreement and waive your right to a trial?
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anyone forcing you to do this against your will? You understand I have to have facts presented to me to find you guilty of these charges and to support a finding of guilt. The state will tell me what those facts are. If you'll listen, please.
In this case, the procedure trial, the proof would show that on or about January 3rd, 2023, the deputies were serving an arrest warrant on Mr. Jaco. Search and arrest, they located a plastic container that contained approximately 8 grams of methamphetamine along with 2 pipes.
I'm not asking that you
Ooh,
agree
more
with those facts,
meth.
Mr. Jaco, but do you understand that's what the state's evidence would be if this case went to trial? Are you satisfied with your attorney services?
Yes.
I feel like Mr. Wanning's done a good job of representing you competently.
Yes.
Mr. Wanning, do you know of any reason why you should not enter this plea?
I do not.
Mr. Jaco, let me just ask you a question. If this were a jury trial where you had 12 people, citizens who were going to decide whether or not you were guilty of a crime, would you have worn that same shirt with a skull on it?
Oh,
He would not.
oh.
I would have
I'm
been.
sure his lawyer might have convinced him otherwise. It doesn't have anything to do with me, but I'm trying to get you to understand it. I hope you never have to enter a courtroom again. But if you do, what you wear and how you present yourself carries weight, whether it's the decider of fact. I'm not going to deny you the right to enter this plea because you have a shirt that might be inappropriate for this, where we are today. But Mr. Wanick, your lawyer, is wearing a suit and a very nice tie. And he's even got a handkerchief stuck down in his pocket. So he's really dressed to the nines because he's trying to present a professional attitude. When you come before a court, it is important how you appear yourself. It doesn't matter whether you're rich or poor or whatever. But when you wear a shirt that has a skull with looks like a spade, a playing card spade on it, it sends a little bit of a subtle message. And that may be what you intend. It doesn't matter to me. I don't care what you wear outside of the courtroom, but I'm just giving you the advice. I've had people that have come in wearing some things that were completely inappropriate, and that cost them in the long run. If you were to come in front of a jury and have that on, then they would probably hold that against you. Most average people would think that you're thumbing your nose at the system, whatever. So anyway, I don't care what you wear outside of the courtroom, but the next time when you come in, just make sure you wear something that doesn't have something like that on, okay? Then Jeremy Jason Jacob, docket number 23 CR 169. On your plea of no contest to count one, the amended charge.
Oh man, he got
Sentence
skulled.
you to 11 months and 29 days in the county jail, suspended to supervised probation, $1,000 fine and cost. And count two, unlawful drug paraphernalia, 1129 in jail, suspended to probation consecutive to the first count, $150 fine and court cost. He'll be ordered as a condition of his probation to complete an alcohol and drug assessment and follow the treatment recommendation. Good luck to you. I hope you didn't take offense to what I was saying, but I'm trying to give you some advice down the road in case you ever have to come back. All right. Thank you. 2020 CR 76, State versus Eric Martinez Marquez. It's a Jordan Sluder, set for trial April 22nd.
Your Honor, I saw Mr. Sluter earlier today. He was in juvenile court when I was down there, and I asked him about this. He was unaware that it was set.
Let's leave it set for his March 11th.
Yes, that's what he suggested, Your Honor. Thank you.
We didn't do Weston Patrick Lee Perry on 2023 CR 99. It's a charge of theft. He's in jail in Hickman County.
He was, apparently, Your Honor. So I spoke to him last week on the telephone. We had a deal worked out that I thought we were going to enter today. And then the bailiffs told me today that when they went to get him, he was not there. I'm not sure where he is, if he's not in the Hickman County jail.
Welcome to the People's Republic of Hickman County.
So he does not have a bond, I assume, correct? We show him to be in jail.
I think he had made bond on this case, and then he was incarcerated in a different case in Hickman County.
Well, then I would say we need to put his bondsman on the hunt.
Got a $25,000 bond with bullseye bell.
There'll be a conditional forfeiture of his bond in the amount of $25,000. The case is issued for the defendant, set for the September DOP day, final forfeiture, which will be September the 25th. Final forfeiture, Sarafation of the bonding company. Did you say it's $25,000? New bond will be $50,000. Let's see if that rounds him up.
If I were to find out that in fact he is at the Hickman County Jail and this is all just a confusion, would it be all right if I added him to the March plea date?
Yes. We dealt with Robert David Sewell in jail. We dealt with Nathan Claude Wallace too as well, right?
We did, Judge.
What are those?
That's my case, Your Honor. And what's going on with that? Mr. Wells in the Hope Center, he was here yesterday, and I spoke with General Arnold. He has some other cases
All
already
right.
set for May the 13th.
Look what I
Assuming he
got.
continues his treatment at the Hope Center, we're probably gonna resolve
Ooh, there's
everything together.
one,
He could just set his case for
two
May the
of
13th.
these.
General
May
Arnold.
There you go,
13th.
baby doll.
Yes, sir.
There you go,
What's
baby
that,
boy.
May 13th?
Thank you.
What good babies you are. What'd you do with
Most
that?
usual
It's on the
show.
floor. It's on the floor. So, found out that Culver's,
Come up.
they charge you for Coke cups, which is just whipped cream. But I don't care.
You have,
As long as they're happy and they will leave me alone now. And we have no more puppy
Bill,
dogs.
you are not indigent to have an attorney appointed when you make
I wish
$700
you
to
guys could hear them
$800 a
licking.
week at your construction job. So your request for a court-appointed attorney is respectfully denied.
Oh, he got denied.
Yes, sir. It's just hard as it is, just having to have a child on the way, and she is at high risk.
I understand. He has a trial date of March the 6th. It's a violation of order of protection or restraining order. Is that your case, John Allen?
It is.
You have any opposition to moving that case to give him additional time to try to retain an attorney? Just put him-
Sir, I have a subpoena that has to be put in for the key witness in this trial date. I was wanting to know if we could move it forward some time due to the fact that the plaintiff thought that the person that called was me, but I did a background check on that number itself and come back to a different person and contacted them. So I have to subpoena them to court.
You want what moved up? Your trial date is, right now, your trial date is March the 6th. And I don't understand what you're asking me to do.
If I could have time for the subpoena to go through and have him here, or I know he lives 6 hours away, or a Zoom call.
All I can tell you is that I'm going to give you a new trial date. What day do you want to give
We're
it?
going to September, it'll be the 17th.
September the 17th, Mr. Bell, will be your new trial date. And September the 9th will be your last day to enter the plea. So you need to either hire a lawyer between now and September or be ready to represent yourself. And if you want a subpoena issued, you can see the clerk's office to request that subpoena.
Oh, represent yourself.
Let's put him on the August 19th for status. We're gonna have you come back on August the 19th and the clerk can give you a card for that. That'll be your next time to
Oh, that'd
come
be
back
so
in. I want to
awesome.
know if you've actually hired a lawyer on that day. If not, you can represent yourself at trial, but we're gonna have the status so that I know what to expect. Okay, thank you. Get that card and we'll take you up. Who else do we have, Madam Clerk?
Lori Lynn Crowder is Mr. Grant, Mr. Jefferson Pickford.
Mr. Eckford, you don't
That's
have a
on your-
job right now. You said you were terminated, is that correct?
Well, yes, sir. I'm not working at the moment. I lost my job due to not having a vehicle. I work out of town and couldn't make it back out.
Happy
Well,
puppy.
this information is true and correct.
I do.
But I find this defendant to be indigent at the present time and therefore will
Somebody just
appoint
burped.
public defender. Do you know if you have conflict in this. It is a drug case.
We do, Your Honor. We previously represented co-defendants Cox and Lee.
God, crud. School lets out at 3:30? What a joke. It's Catholic school. There aren't any kids out here playing the main street. No, it's okay.
You what?
There you go.
Only attorney that's on the case right now is a law firm, Ramsey Thornton Barrett.
On what case?
I think it,
Which case?
his co-defendant.
No, we can't yell to kids. It's a mother walking her babies. Well, obviously, if it's school zone time, guys, we gotta go.
And what is your conflict?
I believe we represented, are there two co-defendants? Cox and Lee.
Fun time is over.
There's Roger Wayne Lee, there's Sharon Lee.
Oh my gosh.
She'll defend Cox.
What is this?
They'll represent Cox.
And Lee, apparently.
And who else represents the others?
Right now, I don't show him.
Well, let's appoint Mr. Mark Atchison.
Buchanan Courtney Cox is being represented.
You yell at them too?
And Courtney Cox is a co-defendant.
Guys, I can't do anything about Blue Dog. Just gonna see somebody she doesn't like. Guys, don't look
All
at
right,
the
we'll appoint
kids.
Mr. Mark Odle. Your new lawyer will be
bad?
Mark Odle.
Oh, here you go.
And we'll necessarily
Tell
have,
him.
I don't know if we'll have to move that trial
See?
date. Normally the trial date
That's
is
a
the
magic
same
word.
as
Tell
May.
him.
May 15th for trial, May 13th for
everybody.
the last day in our retreat. So Mr. Odle is located on that College Street, East College, located on East College Street. You need to contact his office and make an appointment to go in and see him. He'll be notified of the appointment. All right. Remain set for the same trial date.
Thank you.
Thank you. All right, so we're waiting on Mr. Spratt to
Are you done?
finish his federal court. Y'all have anything you need me to sign? Now is a good time.
Oh. I just realized another one. Texas Jim, if you're still here, have you ever heard of the case of Holly Bobo? I think that was her name. She was a nursing student. Holly Bobo. That sounds familiar. I think it's another one. Okay, I got four locations to go to.
I'm literally gonna hand it to Docket. Although it'll also.
Okay, run her down. Oh yeah, yeah. You guys are acting off the hook. You know your mom's not home. Yes, Holly Bobo from Tennessee.
Yeah, and the new charges, one was back in July. But I haven't found I don't think she's been arrested. I mean, it shouldn't be on here.
Oh, I love it when they're mic'd up.
But it doesn't have an record. No.
Let me take a look at it and see.
Rhonda?
I'm telling you, I
No, she wants him to be drawn and quartered.
Don't make me stay here as long as you have to.
Don't let him get my on the wrist.
I was trying.
Real criminal here.
She was trying to sneak out. Doing it. Yes, I remember it quite well. Felicia. Yeah. I spent a whole week last January.
But that's loud.
Like Friday evening. I'm gonna reach out to Leslie and make sure she's been. She had her estimate.
Look at that estimate.
I see that estimate.
The video doesn't say that.
Yeah, that's racist. I'm gonna check in on the general session stuff. Or I may just let.
My mother-in-law ran it.
Annoying way that guy. That's annoying. I know. Oh, it's so bad being a puppy. You can go outside with dad and ride around in cars. They are mad I'm not playing gangster rap. That's what Blue Dog loves.
I know a guy who would do it a lot cheaper.
Daria Haynes. Oh, is that nice? Well, we don't have to.
There before you
I've never.
pay $6,000.
So normally, if they're not yet arrested, it doesn't. Well, no circuit.
Go down to Judge Wallace's court.
Down here. Wait, is that with Aisha May? I don't know. Okay, because I have Brianna Hogan, I have no Sandy. I don't think she's arrested. It has no court date.
Holy cow. I feel like I'm listening to some other stuff.
No, we don't have anything.
Hey, what do you guys want to do tonight?
Yeah.
3 months. You ought to beat me up like that on me. Here's my number. Here's my number.
You don't want to have like a, what's this, Wednesday?
No.
There could be one, but.
Yeah, that's correct. Always.
Sam, you're not back till my leave.
You too. When will I see you? I don't know. Well, here, next month.
Yeah.
Well, you see that? Look at her. She just started clawing at the door.
We'll stand in recess.
Yes, sir. All rise. Court is in recess.
You can get 180 out.
No,
Oh, is it over? Yes, fast group. I agree. Blue Dog will be happy to join you. She'll be happy to. Be awesome. So, let's see here. There we go. Oh, Brown Dog's trying to get in here. Hey, Hey, bud. What's going on? We need to figure out how to get another camera. Oh, wait a second. Don't pull out in front of me. What are you doing? Dorks. Well, what time did I leave here? 1, 2? That was annoying. Why would you do that to your vehicle? Oh, what's going on here? Are they done? Is there movement? Can you guys see? I can't tell. All right, hang on a second. Let's see if there's some moving around. Did this pause? It's 2:45 in Dickson. It can't be done. Oh no, they're still going. Let me see if I do this. Of course not. It doesn't work. There we go. Gosh, I hate this. Oh yeah, it's great. This guy's got an exhaust coming through the back of his truck. Because that's hey honey, we're rolling the windows up. Okay guys. Sorry y'all. Oh look, there you are. There you are, kids. Oh, and then fine, she goes off camera. Hey buddy. Say hi everybody. There you go. Say hi everybody. Say, oh, you come back up. You gonna say hi, blue girl? No, of course not. She's supposed to be a punk. Alright, last stop I gotta make. Do, 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 do. Oh man, we're just coming down front of that car. Here we go. Better give it gas, dude. Boom. All right, I'll be right back. Sorry, guys. What's happened to the court? Thank you, Stacey. I'm trying to get a better picture of them here. Less me, more them. There you go. Thank you. See where she went for it. All right, thank you. Have a good day. All right. So, hey, what you doing? You gonna say hi? You gonna say hi to anybody? No? Hey, Bubba, you wanna come here and say hi? You come here and say hi? We're gonna turn the air conditioner on, huh? How's that? Put your nose up here then, won't you? Holy cow, man. Where'd all these cars come from? I was just on this road an hour ago. Yeah, it's bad when my watch tells me to stand up. Never thought that would happen, right? I'm pulling now. Here we go. Burn. You guys are gonna say hi? Hey. Hello. Come here. Oh, hey, baby girl. Hey, baby boy. All she wants is the window down. Can you hear that? Probably can't. She's like pawing at the window. She has opened this door before, so I better do what she wants. There you go. That's all he wants. He's like, oh, I loves it. I love the smells. I love the peoples. I loves everything. Okay, this is the second white van I've seen today where it has insulation blocking out the windows. I'll tell you what, you guys are gonna be punks. I'm not gonna let you sit there like that anymore. We're just gonna go back and wonder if the trial's ever gonna come back on. Oh well. Mrs. Kagriff says hi to you guys. And Stacey Ann said you're cute. That is not where I want to go. But here is. All right. Well, I thought they'd be coming back, but I don't know what's happening. And I'm about 5 minutes from home. Home being where I'm taking the car and the dogs. I just realized I'm sitting here giving you guys dead air. So anyway, guys, it is 70 degrees right now. Do you know how happy I am? Like, there's no way I can be inside. No way. It is way too blessed of a time right now. And actually, I gotta go inside. I got work to do. But I think we ought to do a stream tonight. What does everybody think? You want to do let's do a party stream. How's that sound? Let's get some people we haven't seen in a while. You guys, if anybody wants to hang out, let me know. Let's do. I've got room for 8. Room for 8. I don't like going over that. Like having myself and 8 others, or just 9, and I could leave, which would probably be better for everybody. Anyway, right? Yeah, we'll have a good time. You know what? It says 70, but boy, I'll tell you what, the windows down, it is colder than I like. Also, it's my haircut. My haircut's got me chilled, whatever you want to call it. So it's funny. My goal today was to go out and I'm looking for stuff. You guys know, okay, let's talk about a little bit about Dollywood. So that's a huge event, right? I'm very nervous about it. I'm getting, I have ideas in my head and I want it to go perfectly, and it scares me if it's not going to be able to. So what I'm doing is like right now I was going out because I wanted to find. Actually, I think I just passed my neighborhood. I did. That's awesome. And Blue Dog tried to tell me. I just realized. Okay, so that's something about Blue Dog. She drives for me, or she is my co-pilot. There she is. And I've missed places before, and I get close to them. She starts hitting the door, or she doesn't hit the door. She hits the dash, and lets me know. Sorry, girl. Doing a U-turn. Didn't expect that to have a little drop off like it did. All right. Anyway, you still see her? Say hi, everybody. Yeah. So anyway, the Dollywood stuff. I'm getting nervous now, honey. Don't you dare! Don't you dare! She reached over for the door handle again. She is tired of being in the car with me, listening to me talk. I'm not playing her music. She likes a little NWA sometimes right about now. Or a little Marilyn Manson. She has a very eclectic taste. But anyway, like today, one of the things I wanted to do was I was looking for stuff for when Baker gets here. I want to make sure he has the best time possible. Okay, he's coming from so far away. I'm just amazed by that, and I don't know. I think this should be. I really think we've got something that really special can happen here, and I'm so excited that I get to share all this with you guys. Like I really am that person. I love having people around, which so many people can't believe. Oh, great. We see kids. No, we can't have kids in the neighborhood, can we? All right, guys. Well, listen, I'm going to put you on mute. I'm going to go settle down, and then I got to get back to the computer if I get anything. I just realized I don't think you have to be on mute. But oh, I switched services. That's cool. All right. I'm going to try to get in here. We'll set up out tonight. We'll talk about it, and then we'll get going. I get Blue Dog out of here. So she doesn't listen. She listens, she hears me, but she's not going to obey me. That's what coonhounds do. Um, the Labrador, he can go anywhere he wants to. He doesn't need a leash because he stays by my side and will listen. Nope. Oh, I just killed it. Are you guys there? I think I just killed it. Anyway, he will listen as if I call him. Blue Dog will mind. So, also, I was not. Don't ever ask me to park. Come on, bud. All right. Let's try and get these idiots inside. You guys make it? All right. Good badges. Good logo. Let's see here. Door get closed. And that needs to go there. There. Hang on a second. That's cool. Get that out of there. And down here. Put this up. Oh, cool. I got 3 of those now. That's special. So, this. I'll real quick. Not the 2 places they're getting napkins today. That's awesome. All right. Come on, guys. Right here. Stifling. Come on. Have to maneuver around a pillow. Go in here. Oh, I hear talking. Oh, that's me. Here. Do that. Uh-oh. Am I still here? I had the microphone turned off. I just now see that. Yeah, I had it turned on the camera. See, I had the phone turned off. I had it muted on the screen. Oh, wait a second. Am I still muted over here though? Oh, you can hear me. Okay, good. Because what's funny is that it still shows. See, look at this. I can't get rid of that one. And it shows that it's you.
You're back with us, so we have 2 cases left on our docket today, and those are both yours.
Rabbit, how are you doing?
Do we have
Rabbit,
one of
let's
them
have a
in
party
custody
tonight.
or both of them? Both of them.
One's in custody, Your Honor.
My wife left me home alone. So let's party. What do you think? Sound good? Just turn to the camera.
Okay.
Why are the buttons doing this? I'm not doing it. Every time I push it. Every time I turn off, I click the thing to take the comment off. It goes up. Well, that was weird. Now it's
I
off.
believe this is your motion to set bond, Mr.
It is, Your Honor, and I'd waive opening statement and call Mr. Crowder.
Raise your right hand, please.
No, I didn't do that.
You solemnly swear affirm that the testimony you give in this case can be
I didn't touch that at all.
what the truth, so help you God.
No. Stop it.
Could you state your name for the court, please?
Roy Brent Crowder.
Okay, and Mr. Crowder, where are you currently being housed?
Dickson County Jail,
Okay, and how long have you been there?
4 months.
Okay, and
I'm not
before
touching
that,
it.
were you on unsupervised probation?
Yes, sir.
Okay, someone's messed up. I don't know. I've got an external
Were
mouse. I don't know where
you,
it is.
So you were you reporting to anybody at all?
No, sir.
During that time? Okay. And how long have you do you live here in Dickson County?
I've lived at 2451, 2452 Highway 48 South my entire life.
Okay. Is that here in Dickson County?
Yeah, Dickson County.
Okay. And can you tell the court a little bit about your family situation at home?
Yes, my mother fell when this happened on Halloween. She couldn't get back in the house, and she's been in, she was in intensive care and asleep for a month, and then she had to have a trach put in. Now she's going through a rehab hospital, and I just need to get up there where I can get her home and take care of her.
Okay. Do you live with her?
Yes, sir.
Okay. And have you ever had any issues showing up at court?
No, sir.
Okay. No convictions for failure to appear?
No.
Okay. Now you have a warrant for a violation of your probation, right, to start with?
This time?
Yes, sir.
Yes, sir.
Okay. There's since been an amended warrant, right?
Yeah.
Okay. And the first warrant, was that based entirely on new charges?
Yes, it was a domestic.
Okay. I'm gonna hand you some documents. And Mr. Crowder, are those documents where those charges were dismissed?
Yes, sir.
Okay, Judge, I'd like to move those into evidence. They're not certified, but I'd ask the judge.
Is a certified copy or a non-certified copy as good as a live witness?
Well, in a bond motion, I think it's different. In a bond, well, I mean, she can object to hearsay if she wants to, but we're dealing with it.
I'm gonna overrule the state's objection, allow introduction of these documents.
Judge.
Liable hearsay.
Yes, sir. And were those charges dismissed, Mr. Crowder?
Yes, sir.
Okay. All right. And so do you have and I don't want you to talk about specifically, but do you have some other charges that are specifically?
Yes, sir.
Okay, and you have a different lawyer for those, is that right?
Well, I got the, public defender, but I want to get out and hire a lawyer.
Okay. And there's some other financial obligations you need to take care of?
Yes.
And, do you need to, you said there are other financial obligations that you need to take care of? Okay. And,
That would be through my stuff to do for my mother, you know what I mean?
okay. Is she in the hospital right now?
Yes.
What's wrong with her?
Been there since, Halloween, October 31st, when this happened,
She fell.
getting back in the house.
Okay. And how much do you think you could afford if the court were to set you a bond? How much cash do you think you could come up with?
15, 20,000.
15 or 20,000, or the bond be set at 15 or 20,000?
The bond be set at 15, 20,000.
So could you come up with 1,500 or 2,000 then? Is that what you're saying?
Yes, sir.
Okay.
Now I can't hear anything.
Those are my questions, Judge.
Sorry, when I put my earphones in, it messes it up.
John, you have a question?
Now, Mr. Crowder, other than the domestic, you've received other charges while on probation, is that correct?
This time?
Yes.
Yes.
And those have been bound over to circuit court.
Yes, ma'am.
And there's actually a 7-count indictment. Does that sound right to
I
you?
don't know how many it is.
Okay. One of those includes violation of bond conditions
Is that working?
on the victim of the domestic.
Okay, well, all that's been dropped.
Okay. So let's go back to the
Kind of
question.
working.
Okay. One of the charges that you have in circuit
So all this
that
is
you
now
bound
going through my
over
phone.
is violation of the protective order on that domestic.
Well, that was.
Okay, no.
Okay.
We're not talking about the domestic.
Okay.
We're talking about the violation of the bond conditions on the domestic. Those two things are separate. So the domestic being dismissed does not get rid of the violation. So one of the charges you bound over was violation of bond conditions. Is that right?
Yes, sir, yes.
Okay. And if there's a violation of bond conditions, it would be with that victim of the domestic that was dismissed.
Well, those,
Yes or no?
yes,
Now, were you on unsupervised status during this time?
yes, ma'am.
So you were not receiving drug screens.
No, ma'am.
When's the last time you received a drug screen?
I guess it was in November, December of 22.
Now, who, if anyone else, lives at that house with you?
Me and my mother.
No other family members?
No.
And where is your mother right now?
She's at Specialty Select Hospital in 2000 Hayes Street in Nashville.
So she's not at the house by herself?
No.
Nothing further, Judge.
Mr. Crowder, if there were other conditions put on your bond, something like that, where you had to go take drug screens or anything like that, would you be willing to comply with those orders?
Yes, sir.
Okay. What if they had you report to a probation officer while you were on bond?
I'd go every week.
Okay. All right. Those are my questions.
Ray Cross?
No, Judge.
Call your next witness.
Sorry, proof, Your Honor.
And it is rested as proof on the issue of bond.
State will call Officer Christina Bright.
Officer Bryce will come around.
And Judge, for the record, I did not object to those general sessions records. I said I did not object.
Yeah, have a seat, raise your right hand.
Do you solemnly swear or affirm the testimony you give in this case to be the truth, the whole truth, nothing but the truth, so help you God?
Are you Officer Christina Bright?
I am.
And is the defendant Roy Crowder on your caseload?
That's correct.
Now, he was on unsupervised probation at this time.
At the time of the domestic.
Okay.
How did that happen? How can someone on a 12-year felony sentence, even on probation, be on unsupervised probation?
I'm pretty sure he was a drug court graduate back when Judge Birch was here, and they automatically went to unsupervised after they graduated.
Hey, I can do that, but I got no way to hold it.
And you have filed an original and an amended, is that correct?
That's correct.
Okay. The original was based on the domestic. Is that
I'm having
right?
such a hard time
Yes.
today.
Was it based on any other grounds?
Not the original, no.
So let's talk about the amended. What were the grounds for filing the amended?
That was new charges that he had picked up of simple possession, casual exchange, ×2, unlawful carrying or possession of a weapon, resisting arrest, possession of drug paraphernalia, manufacture, sell, deliver, possession of meth, and violation of order of protection for the domestic.
Now, with a 12-year sentence, is he a convicted felon?
Hey,
What was his prior felony?
I'm doing this all through the phone now.
Was it drug related?
Initiation process to manufacture meth.
What bond did
Oh,
he seek
so
on
glad
this
you can
case?
hear me.
Hold for hearing.
CCN,
If the judge were to give him a bond,
life is
are
work
you
for me.
asking for any
Life.
other conditions such as reporting if he's released?
I will, yes.
I have nothing further at this point, Judge.
Brad, do you have questions?
Yes, sir.
I'm gonna try to eat my burger, so
Mr.
I'm
Bright,
gonna turn the camera off.
Mr. Crowder has reported to you before, hasn't he?
Yes.
Okay. And during that time, he takes screens and that stuff for you and report like he was supposed to?
So he was on supervised probation, and he had picked up new charges at another point, at a
Nice
different
and
point.
greasy.
That would,
Your burger should be.
took him off
There's wrapper cheese.
unsupervised.
Love it.
Those were dismissed, and he went back on unsupervised prior to this.
But during the time that he was reporting to you, he did what he was supposed to do, right? You didn't do any amended
He
warrant?
wasn't technically reporting to me.
Well, it was a condition of his bond that he reported to you, though.
Yes, and then I did give him a drug screen. I think the last one was December 14th of 2022.
And he was good to go?
It was negative at that time.
Okay. And he never violated his bond conditions in whatever he was supposed to do towards reporting to you during that time either, did he? There was nothing that caused you to do an amended warrant at that time?
No.
Okay. Those are my questions, John.
Can I redirect, Judge?
Thank you, Officer Bright. You may stand down. Anybody call your next witness?
The state's proof, Judge.
It is rested. You have a rebuttal proof, Mr. Spratt?
No rebuttal proof, Your Honor.
You're in argument.
Judge, Mr. Crowder, I think his first warrant, based on those dismissed charges, is going to be dismissed. He does have an amended warrant based on these other charges. Right now, the public defender's office represents him on those. We heard no real proof on likelihood of conviction on those charges, which is a factor under 4011-118. What we did hear is that Mr. Crowder has lived here his whole life. He's never failed to appear in court. He has been supervised briefly by Officer Bright before and did what he was supposed to do there. So I think if the court were to make that a condition of his bond, I think he would do it again. We've heard testimony that he could afford a $15,000 or $20,000 bond. But the court's well aware of how the trial schedules proceed, and I understand what he's charged with, but there are a lot more, I won't say serious, but dangerous cases that are taking precedent over these kind of cases. So, I mean, if his mother's in the hospital, he needs to help her. And so we're just asking the court to set a bond at $20,000 so he can get out. He does maintain the presumption of innocence on those charges. And Judge, whatever conditions the court would impose on a bond, he would comply with those. I think that was his testimony.
Judge, I believe a hold for hearing is appropriate on this case with the length of the sentence and with the new charges. You have someone who's picked up new felony charges involving a firearm. He was in the presence of the victim on the domestic when this took place. I would ask that if the court releases him, that not only is he required to report to probation, that he is required to submit to drug screens. I would ask that he would also be prohibited from having contact with the victim where
Is
he's
the victim his mother?
No, it was a paramour. And along with that, potentially a GPS or house arrest.
I'll just briefly respond about the alleged victim is that that case was dismissed. And I mean, I think
McKinley.
the alleged victim does.
My entire stream's messed up.
So, I mean, whatever the court does, the
Hey,
the number one
what do you think about tonight?
Does or does not want to have contact.
Gonna have a party.
And I can't testify, but I know.
I don't like how any of this stuff
I mean, the
looks.
case,
Have contact.
yes, the case has been dismissed since, and I've been contacted. I keep, but any other
Changing my
conditions-
angles right.
Bond will be set at $20,000.
I did not touch that.
Conditions of his bond are that he begin reporting immediately to his probation officer.
So I have to do this through my phone because I left.
Undergo weekly drug screens.
I came back in for some reason. I can't click the stuff.
Positive will be grounds for the revocation of his bond.
I can't click. Like I can click that, but then look.
In addition to that.
Oh, I worked that time.
You know, I was considering a GPS, but that becomes.
I'm going through my
expensive.
earphones instead of my microphone. I hate all this.
He will be under house arrest. He's not working, if I understand correctly. So if unless he is working and employed and shows proof of that to his probation officer, he'll be under house arrest. He can go to his lawyer's office, he can come to court, and he can go to the hospital on an emergency basis. Beyond that, he has to have permission of his probation officer before he leaves his home. That's the judgment of the court. Ready for the last case?
Anyway, McKinley, tonight, party stream. We can go party stream. Hey, look, what if I did this? There's my drink.
State versus Cordarius Godwin, is that the case?
There you go. A little bit.
All right. Motion to revoke bond.
That's another reason why I love the name The Expert. Because I'm an idiot. Nope.
Judge, for the state's proof in this matter, I'd like to present the court with certified records from the Lawrence County Circuit Court that include his warrant on new charges, his binder,
Okay, I need y'all's help.
and the new indictment that have been showed.
Pick out a thumbnail for the
And that is the state's proof
stream
in this matter. I have no opening, but would like to give a closing.
tonight. I did based off Miss Kagriff's wine and
proof on the grounds for
thing. Hey, let's go, Farrell. How are you doing?
Judge, I would move for the court to dismiss
Which
the
one do y'all
state's
like?
motion based on the due process requirements outlined in State versus Bergens. The documents that were just entered in front of the court, while they won't survive necessarily a hearsay objection, Bergens does say that the state must have a corroborating witness, which was just the converse of what we had in the last hearing. even though General Bryson didn't object to those hearsay documents, there was a witness in the last case that could testify as to what happened in those. My understanding is that the officer from Lawrence County was going to be here today. So I didn't subpoena him. I didn't find out that he wasn't going to be here until today. And with that being, I can't cross-examine those documents. And in the arrest warrant there, it doesn't say how the officer identified Mr. Godwin. So I can't cross-examine him about that, even though I have Mr. Godwin's discovery from that case. I came here today prepared to cross-examine him about it. I can't do it with just that piece of paper there. And Bergens, and I do know that General Bry, I have appealed this issue, and I respectfully disagree with Judge Lockert Mash and Judge Easter respectfully, that the issue is not that it's not the hearsay of the documents. It's the fact that the due process requires them to have a corroborating witness.
MG law, my
because the defendant,
whole stream's messed up. I'm having to do it through my phone.
It's
awful, dude.
Allowed specifically the right to confrontation, which I don't necessarily see how that divides itself from a hearsay objection. but
Everybody's getting tired.
It does. So I would argue, one, that had I not thought the officer was going to be here, I might have subpoenaed that officer. So, I mean, in the alternative to dismissal, I'd ask the court to pass the motion or hold the motion, and we can get the arresting officer up here sometime in March to do this. These charges are about 6 months old. So I don't think that just giving the court those hearsay documents is enough when you weigh it out with his due process rights and his liberty.
Let me just shorten this for you because I have a grandson I need to get to see. On
Ooh.
the argument that
When the judge brings up the grandson, it's
Pratt
over.
makes regarding
Court is
the
over.
production of the certified copies as being insufficient under Bergens. As the state has submitted, there is a decision of the Court of Criminal Appeals, an appeal from Dickson County. I'm not sure who the judge was at that point in time, but it was a decision from the Court of Criminal Appeals by Judge Tim Easter, entered March the 3rd of 2023, a little under a year ago, on an appeal in the state of Tennessee versus Robert L. Thompson. In that case, the same argument was made. It was essentially a person who was on bond, and that his bond was revoked based upon evidence of certified copies of shoplifting and some driving charges that the state introduced during its hearing on the motion to revoke bond.
Wendy, how are you doing?
And that the Court of Appeals and Judge Easter
Wendy, you
addressed
doing a
the
party
issue
stream
of
tonight?
the right to pretrial release and so forth. And it does mention that our Tennessee Constitution guarantees a defendant the right to pretrial release. Our Supreme Court has ruled that right is not absolute, and it may be subsequently forfeited based upon the defendant's conduct. And that cites the Bergens case that Mr. Spratt cites at 464 Southwest 3rd at 301. The controlling statute provides that a court may revoke and terminate a defendant's bail if, after the defendant is released upon personal recognizance, an unsecured personal appearance bond or other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or other proceedings. Then the court may revoke and terminate the defendant's bond and order the defendant held without bail, pending trial, or without release during the trial. That's citing Tennessee Code Annotated 4011-141. Before a trial court can revoke a bond under the statute, either sua sponte or upon motion of the state, a defendant must be afforded due process. And that cites the Bergens case. The Supreme Court has promulgated the following procedure to ensure compliance with the requirements of the 14th Amendment in Article 1, Section 8 of the Tennessee Constitution. It goes on to set forth what the Bergens case said were some of those due process things. It goes on in the next page to say that the trial court has very wide latitude in setting bail. and that an appellate court shouldn't be most reluctant to second guess a trial court's decision. In this case, it goes on to talk about the defendant's lone argument before this court is that the trial court erred in revoking his bond based solely on certified copies of the shoplifting and driving charges introduced by the state during the hearing on its motion to revoke bond. The transcript of this hearing reflects that no witnesses testified for either party. So this case is identical in factual basis to where we are today. No witnesses testified today. No witnesses testified in the Thompson case. The evidence of the new charge was submitted as an exhibit by counsel for the state. That's what happened in this case. The defendant objected to its introduction as testimonial hearsay, and he insists he was unable to effectively challenge its admission. This court disagrees. As the Supreme Court recognized in Bergens, due process requires notice and opportunity to be heard at a meaningful time in a meaningful manner. For procedural due process, a meaningful time is one that gives the accused timely and adequate notice that a hearing regarding the deprivation of a right is scheduled to occur. A meaningful manner is one in which the contents of the notice are neither ambiguous nor obscure, but clearly inform the person of the nature of the charge against him or her. The notice must also be reasonably calculated under all the circumstances to apprise interested parties of the claims of the opposing party, and it must allow adequate preparation to reduce surprise. The individual must be provided an effective opportunity to be heard, defend against any adverse witnesses, make arguments, and present evidence. Implicit in this opportunity to be heard is also the opportunity to respond either in person or in writing with reasons for a proposed action should not be taken. And it goes on to say again, bond revocation hearings are somewhat flexible and hearsay evidence may be admitted when the trial court finds it is reliable. As the state correctly observes, the certified copies of the new charges against the defendant are self-authenticating under Tennessee Rules of Evidence 902. Thus, the trial court acted well within its discretion in accepting that evidence as proof that the defendant received new charges for the offenses committed while he was released on bond. Moreover, the ad hoc record before this court reflects the defendant received the procedural due process required by Bergens. One of the trial court's ultimate concerns was when making a decision about a defendant's pretrial release is protecting the safety of the public. The code requires an individualized inquiry into each defendant's condition. The information before this court demonstrates the trial court did just that with respect to the defendant in this case. The trial court had the discretion to revoke the defendant's bond under the circumstances presented, and therefore, in regard to your motion to dismiss, Mr. Spratt, it is respectfully denied based upon the ruling of State versus Thompson. Do you wish to offer any proof?
No proof, Your Honor.
Any argument to be made then on the merits of the revocation? I'll allow the state to go first. And I apologize to General Bryson for requiring you or interrupting your, I'm sure, loquacious argument about the meaning of that Thompson case, but I had read it during the lunch hour. So.
Thank you, Judge. The defendant in this case is out on bond, not only on the subject docket case, but he has received several bond on bond charges, and the state has not up until this point filed a motion to revoke. At this
Wendy,
point,
I've got this thing
with
I
as
time off
many
finish this
bonds
because
as
it's just
he
a little
is
bit
out
longer.
on,
But I
the state
will
feels
call you
that
back.
it is more than
So
appropriate under Tennessee Code annotated 4011-141, and that the defendant's bond on the initial charge in 2020 CR 192 be revoked as a result of his charges with driving on a suspended license, reckless endangerment, and evading arrest.
Mr. Spratt?
Judge, it's discretionary with the court as to whether or not to do this. I mean, these charges are 6 months old. Again, I take issue with the reliability of the documents that were put in as proof. And you know, I would cite to the Bergens case, Judge Easter's opinion, that was my case. That's non-published opinion. So I don't think the court has to follow it, but
ooh,
I
non-published
believe in the
opinion.
Bergens case, it says explicitly.
My case.
that the
Gotta
state
be
must have a
published, dude.
corroborating witness. So that was not
Gotta be
started
published.
up. The Thompson case was not. It was not started up to the Supreme Court. So, and it's not mandatory authority. Mr. Godwin is charged with, he's charged, and the court's got the documents in front of him. There is no indication of as to how that officer identified Mr. Godwin. And again, just I'd ask the court to hold ruling and let us continue this hearing, because I was under the impression that this officer would be here today. Whether he had something go on this morning or not, I didn't issue a subpoena because of that. So I would ask the court to at least delay ruling on it and let us reopen proof and get the officer up here sometime in March in the court's regular docket. The nature of the charges that Mr. Godwin's, that are the basis for the state's motion, are nowhere near in the same area of the charges that he has pending before this court that we're going to trial on in September. So, and he has shown up repeatedly for this case. So I would just ask that, one, either the court dismiss it or choose not to, or put some different restrictions on him, or two, allow us to open up and have proof later and get the officer up here.
State, have anything else?
Judge, I will tell the court in full candor to the tribunal that I had anticipated, I had spoken to you and had issued a subpoena to this officer. I'm not sure if it had been.
Thank you, MG Law.
served,
Well, I'll tell you what, dude, I'm gonna start
but
calling
he
you
also
Professor,
had
man.
court in Lawrence
Because
County.
that is
Not
a,
available.
I mean,
I
I
do
do
feel
not
that
know
the
how
issues
you're able
raised
to
about
put that
necessary
in
testimony
the
are addressed
exact
by the opinion of Judge
words
Easter.
that it should be in. That was really cool. Unpublished opinion would not be present, but could be potentially used as persuasive. I mean, dude, that's just awesome. Like how that knowledge just pops out of your head, and like that is the standard everywhere.
Well, that portion of the Bargains case that Mr. Spratt refers to is.
Start calling him the professor. He has that hat, professor hat.
In the Thompson case.
Professor Cat, too.
I think this is what Mr. Spratt refers to, and it says that.
Sorry.
The Supreme Court in Bergen stated that the defendant in a due process situation is entitled to written notice of the alleged grounds for the revocation of his bond, a time, the date, time, and place of the hearing, disclosure of the evidence against him, a meaningful opportunity to be heard and to present evidence, and the right to confront and cross-examine witnesses, right to make arguments in his or her behalf. And then goes on to talk to the court must conduct an evidentiary hearing in which the state is required to prove by preponderance of the evidence.
An unpublished opinion is one that's not been put into the West or
in my opinion,
system, into the reporters. Excuse me, West
the right to confront and cross-examine witnesses does not mean
it's not put into a book, but it is an opinion. It's held in court, and
simply going to say.
Usually they're just kind of forgotten unless somebody keeps them. But MG Law will come around in a second and give you the correct
It's like
response.
requiring the state to put on proof about other matters that are a mini trial, which the Supreme Court says is not required. In other words, the officer who might have charged him with those charges.
Like all these opinions today in court aren't going to be published.
Is not the issue. The issue is whether or not those situations arise to the fact that it violates the statute regarding his release on bond. And in fact, the Supreme Court in Bergen says that it is not, the requirements for the revocation hearing are flexible, and that the trial court shall be able to consider factual testimony, documentary proof supporting the grounds, but it is not, need not be a mini trial of the alleged conduct constituting the grounds for revocation. What it appears to me is that Mr. Spratt's argument would amount to the requiring the state to put on a mini trial of the officer who charged the defendant with those offenses, and therefore I don't find that the Bergen's case requires that. In this particular case, the defendant is charged with the offense of sexual battery without consent and vandalism up to $1,000. One is a Class E felony, the other is a Class A misdemeanor. And they are set for trial in September, if I understand correctly. The new charges that are before the court on with the certified copies and the court accepts the certified copies as being competent evidence, indicate that on or about August the 11th of 2023, it indicates that the
Can you hear him just
investigator,
talk about
Anthony
rules of
Kutcher,
evidence?
did attempt to initiate a traffic stop on Highway
If the
43
certified
north
copies
on
will
the
be
white and color sports
admitted as
bike
evidence.
traveling north due to several traffic violations. On initiating emergency lights, Cordarius Godwin did turn right on Highway 64 East. He failed to stop and then did increase his speed, exceeding over 110 miles per hour while passing traffic, and that he ended the pursuit at that time due to the safety of the public. Goes on to say that, of course, the reckless endangerment charge was part of that, and the evading arrest charge was also a part of that. So all of these were one incident that occurred. Part of what the Thompson case points out is that release on bond is perhaps a right in some situations, but it's also the court's obligation to consider the issues that whether or not the defendant's conduct justifies the revocation of bond. It also requires the court to consider the issue about whether or not the public safety is considered in revocation of someone's bond when they have new charges. And this court is of the opinion that the defendant's conduct on the new charges constitutes a disregard for the safety of the public. Therefore, I grant the state's motion to revoke bond. He'll be held without bond pending his trial. He is rendered into the custody of the sheriff.
Judge, may I pin something in the Bergen's decision to the court really quickly? At the bottom of page 310, in the Bergen's decision, it states
There goes
specifically,
that
in addition to
decision again.
documentary proof, the state must also prevent testimony from a corroborating witness or witnesses as of the facts supporting the allegations.
He is hellbound on this because it was his case.
So that Judge Easter never reached that sentence either. So I don't believe that sentence is dicta. But I mean, I guess I'll find out. But I mean, that's what it says as far as the due process goes. So.
Well, I've made my ruling, and basically I've relied upon the Thompson decision, and the facts were pretty much identical in that case to the present case, and therefore I found that that case is controlled. All right, that concludes our business for today, so we are adjourned unless someone has something else.
General Brooks sent this for you to sign, that you asked him to change.
We go over here and the sun's in my eyes. Ah, jeez. Everything's a pain here. So that's it, man. A lot of people went to jail. Is that a cop right there?
What
Nice
day are you
haircut.
wanting to set this on? It's not. When are you wanting to have this individual?
I wanted to do my hair.
It's not in this one.
Oh, lovely.
All right, guys. Before we go, I need you to vote.
Lovely. May I email this afternoon or tomorrow morning?
Top left, top right, bottom left, bottom right.
Fill it in.
What do you like? Gonna do the a party stream.
Well, this information.
Ms. K-Grove said wine and YouTube tonight. So I typed in, this is the AI. My genius mind was boxed wine. That's what boxed wine looks like. Oh, was it really, McKinley? Well, heck. Send me a link to it. Unless it's boring, you don't want to do it. Oh, it wasn't recorded? Oh, yeah. So how about this? Which one do you like? Top left, top right, bottom left, bottom right. Need it real quick. I'll take the first answer. First person that comes in with an answer, I'm going to do it. It was streamed but not recorded. That's weird. Top right says Miss Kager. That's the one I liked. I really did because it's all the cartoon look. All right. That's your idea and your suggestion. Oh, McKinley came in at the top left. Uh-oh. Uh-oh. Do we have a tiebreaker? Look at those big hands and little bottles of wine. There's MG Law. Look at that. He pulled over to answer this. Rabbit says bottom left. Oh man, we got everything up here. All right, so the appellate courts issue opinions which they choose not to publish in the official court reporters. The opinion is binding on that particular case, but is not precedent for any other cases. That is that's what you need. That's the flashcard answer. What you need to study for the final. All right, guys. Anyway, all right. The judge here, they turned the sound off. They're ready to get out of there. They're like, no, we turn the sound off. We still got the camera on though, so don't do anything. Don't pick your nose. Was they're telling the judge. Anyway, guys, listen. I appreciate y'all. Thank you for going for a ride with me. The lake was cool. I got a new place to take White Rabbit when she comes back. If she comes back, I was her. I bet she can get a lot better options than me. I just made myself sad. How do I end this? Boop. All right, there you go. Anyway, guys, thank you so much. That was fun. I like that guy. Here's the thing. I was over there. I was watching this morning. I was looking for a case. A Tennessee State representative, former representative, is having a hearing today. He's having his arraignment hearing. He had some DUIs and stuff like that. And he got arrested in January in Florida for DUI. So there's some problems there. But anyway, I was hoping that case was going to be streamed today. And it wasn't. Davidson County Criminal Court. And that's what I was looking for. And so anyway, I saw this guy in the chat. Somebody started making fun of one of the prisoners. They said, "Oh, that looks like Gloria Johnson, who happens to be a state senator in Tennessee." And anyway, after that, hey, Roseland Ranch. After that, they put on subscriber mode, and I was like, "Well, I'm already a subscriber." I was like, but it made me angry because like the comments afterwards, where people were like being like, "Oh, good, it's on subscriber mode now. We won't have all this blah blah blah, whatever." I was like, man, you know what? There's people in here watching this. Like, I like the guy. It's local. I want my own chat, so I ran it just for the chat because I was like, you know what? Some people just want some background noise. I kind of needed that today. Getting Wet Rabbit out of here, and anyway, it was fun. But tonight, what's a good time for everybody? 8 o'clock? Can't be 9, man. I'm done with 9 o'clock. I can't do it anymore. I just say 8 o'clock because it's like 3 hours from now. I was gonna say 7. We'll work at 8. Try to do 8. Get your wine. Get the party going. Need some people up here. So if you're available, let me know. We'll do a party. Rabbit is all about the party. Awesome. You guys know, send me a message, Discord, Twitter. I might be on. I won't check email. I know I won't. If you see somebody, see an angel floating around, give them the message to get a hold of me. They can get a hold of me pretty easily. Anyway, listen, guys, love y'all. Thank you. This was fun, man. It's just a cool little family. You get to mock fun of everything. And thank you for babysitting Blue Dog. She enjoyed that. And I will. Can I even do this? Because I'm on a computer. I don't. I think I can.
Well, I woke
See you
up to
later. 8 o'clock ish, right?
Well, I
Deuces.
woke up to go get me a cold pop. Then I thought somebody was barbecuing. I said, oh Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. And then the smoke got her. I got bronchitis. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Well, I woke up to go get me a cold pop. Then I thought somebody was barbecuing. I said, oh Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. I said, oh Lord Jesus, it's a fire. I said, oh Lord Jesus, it's a fire. I said, oh Lord Jesus, it's a fire. Jesus, 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 it's a fire.